Hi everyone, it's Wayne Jones, the course coordinator for statutory interpretation. This week looking at chapter 10 in the textbook, which deals with statutory presumptions. These are presumptions that the courts are entitled to make based on previous law, previous history, etc., when they are interpreting a piece of legislation. So that's the background to them. But don't forget that we're talking about common law, the same as we were last week when we talked about common law rules, and that included the Latin maxims that we refer to. These presumptions just form part of the toolkit that you can use when you're trying to work out the meaning of a piece of legislation. But don't forget this, statutory presumptions can't stand in the face of clear words. So, very important point right up front, these presumptions can be displaced by the use of very clear words in the legislation, which just say, for example, this legislation might act retrospectively, for example. They vary in strength, and some are falling out of favour and others are emerging as part of the new landscape. Look, the first one to look at is the fact that legislation doesn't usually have an extraterritorial effect. So when courts are looking at an act, they're quite entitled to presume that it's only meant to apply within the jurisdiction within which it works. And here it is getting statutory backing in the Act's Interpretation Act for the Commonwealth. You'll see here that references to localities and jurisdictions, etc., are expressed to be within the Commonwealth, so within the Commonwealth of Australia. So there's statutory backing, if you like, for the presumption. The next presumption is that legislation doesn't take away the jurisdiction of the court. Now, this is certainly one that there's always a creative tension between the government of the day and the courts. You'll often see examples of new legislation around issues such as border protection attempting to take away the jurisdiction of the court to review government decisions. Nevertheless, it remains a fundamental part of the rule of law that courts can and do have an overview of legislation. Citizens must have access to the courts for the purpose of settling disputes, and providing access to the court is seen as a fundamental function of government. So legislation doesn't take away jurisdiction from the courts. It is possible, though, for arbitration in a contract to specify that the parties are meant to submit to arbitration rather than go to a court. But even in that case, awards can be set aside for administrative reasons such as the bias of the arbitrator or in the case of procedural fairness. There is a presumption that legislation doesn't bind the Crown, and this really goes back to the separation of powers and the view that the legislature and the Crown are two very, very different entities. The usual language at the beginning of the Act is something along these lines: this Act shall bind the Crown, and that's the situation in a lot of Queensland legislation, for example. Note that in Queensland there is a specific provision, section 13, which talks about the fact that acts aren't generally, or that is legislation is not generally binding on the Crown unless express words are included in the Act for that purpose. Referencing the Act being binding, for example, to all persons is not sufficient. The legislation must use the words binding on the Crown. Do note that there's certainly a case example of Bropho and Western Australia which suggests that it might be possible that even in the absence of the use of those words, it could be found that the legislation is binding on the Crown. Context and purpose will always override the presumption because that's what we do now in the modern way we interpret legislation. And in that case, for practical considerations, namely the the High Court found that about 93% of the state was covered by Crown land. The Act in question, which dealt with Aboriginal heritage, wouldn't have any work to do if it didn't apply to that Crown land. So the High Court found that it did apply, and it did so. It did apply to the Crown, notwithstanding that the Act had nothing to say on the topic. As you'd probably expect, penal provisions are to be strictly construed. So, bearing in mind that the state has all of the power, all of the resources at its fingertips, not unusual for there to be a presumption that penal provisions in legislation are fairly strictly construed. The judges are tending to use slightly different language around this now. The modern approach, for example, as we saw in this case of George and Rocket, was to, rather than say penal provisions are being strictly construed, is to look at the specific example, in this case a series of rules around the issuing of search warrants, and say insisting on strict compliance with the conditions governing the issue of a search warrant is simply to give effect to the purpose of the legislation. So sometimes the courts get there in any event without necessarily referring to the presumption. And the flip side of that coin is that remedial provisions are fairly broadly construed. So you've got penal provisions being construed in favour of the citizen, remedial provisions again construed in a way so that the maximum benefit flows to the public. There is a tendency towards the greater benefit to the individual, talking about things like how social security, how pension benefits, how occupational health and safety legislation is construed. And turn your mind back to the case exercise in 5.4, Parrott's case, where the farmer who looked like he was going to miss out on being able to apply for assistance to leave the land had the benefit of the legislation being stretched to include his situation, where he was no longer actively working as a farmer, but he had been a farmer, he had been a primary producer. This is probably one of the presumptions which is on the way out, that tax provisions are normally construed in the taxpayer's favour, but I think we're probably now well and truly down the track towards purpose and intent, rather than relying on this presumption to get a benefit for the taxpayer. The presumption that legislation approves common law interpretations of words is still very much alive. Part of the whole issue around context. So if there's been a string of cases, there might be a word that's defined, and in that case it has if you like, a common law history. It's presumed that if those exact same words are used in the legislation, then the legislature had that in mind when they produced the wording of the new Act, and so that becomes the accepted definition. And the textbook gives you a great example around whether union, or the collection of union fees, was truly an industrial dispute, and the words that we used were whether or not such a deduction was a matter pertaining to the relation of employer and employee. That definition has now found its way into a number of iterations of the Fair Work legislation, so it's now an accepted definition. Another big issue is this one around legislation not acting retrospectively, except in the absence of words to the contrary. Now, you'll see examples such as re Wakeham ex parte McNally, where it can operate for good, so in other words, to give a benefit to the citizen. And in that case, you might remember, was the one where there was some jurisdictional problems with the family law legislation. So just to make sure that 12 years worth of court decisions didn't throw the whole of the system into disrepute, legislation was passed to retrospectively validate those decisions. The not so good, have a look at the reading on the Tampa case, which essentially just said that a whole lot of otherwise very illegal activity by the Australian government around the arrest of the motor vessel Tampa were made lawful by retrospective legislation. The legislation, in fact, if you have a look at the preamble to it, says just that, an act to validate the actions of the Commonwealth and others in relation to the MV Tampa. So, yeah, an example, but not a terribly good one. Yet, generally, when you're looking at legislation and deciding whether it's going to apply retrospectively, you think about two cases. The first is Rodway against the Crown. That was the case about the admission of uncorroborated victims' evidence. Previously not allowed, but after an amendment it was allowed, provided there was a warning to the jury. Now the offence, the act performed by the accused person happened before that amendment, so he quite naturally argued that, well, the old law should apply and the uncorroborated victims' evidence shouldn't be allowed in. But the court said no, that was procedural in nature, it wasn't substantive, so that they decided that they would let the uncorroborated victims' evidence in, provided the warning was given to the jury. And then you contrast that with Maxwell and Murphy, where the law regarding the time limit for making an application for compensation changed from 1 year to substantially longer, and although nothing was said about any transitional provisions. In that case, the court took a slightly different view. They didn't say, is it procedural or is it substantive? They said, well, it probably looks more like this. Is it a statute which creates or modifies or abolishes substantive rights or liabilities? Or is it a statute which deals with the pursuit of those remedies? So, similar language, but quite clearly different. And in that case, in Maxwell and Murphy, they said, look, to extend the limit would be to create a new right which didn't exist before. So to that extent, the amendment became a statute which abolished a substantive right, and it couldn't act retrospectively. Legislation doesn't remove property rights. This one probably goes all the way back to Magna Carta in some way, in that it's the inalienable right of a person to own property and to be immune from the state just arbitrarily stepping in and taking that property away from them. Plenty of authority in the textbook around this, but consider the couple of cases which deal with mixed purposes. The first one was the Mandurah Enterprises against Western Australian Planning Commission case. The words in question there were for the purpose of public work, and that purpose, that public work was constructing a railway. And in that case, the company, the council took more land than was required for that specific purpose, and so that particular acquisition was struck down. In other words, it was presumed that legislation didn't remove fundamental property rights except for the public good, and so it was very strictly read. The other example was the case of Fazzolari, and it's the one where the land was seized, was compulsorily acquired, partly for the purpose of constructing new council offices, but unfortunately it had to go through third-party hands, a company called Grocon. They were going to make a profit out of the deal, as well as building the new office for the council, so that one was struck down as well. But have a look at the details of both of those cases. Just to finish off, please make sure you have a look at these specific other statutory presumptions as well, because they will come up for you in practice a lot. The first is there is a presumption that if the Crown loses a case, and now I'm not talking about being unhappy with a sentence in a criminal matter, because they can be appealed, but if a Crown does lose a case, they don't usually have a right of appeal. And the second is that Parliament doesn't intend to deprive a court of the right to become involved in and ensure that a party receives natural justice in a government decision-making process. Again, that will come up for you quite a bit. This is a very important one. Every offence, so in that case, think of offences such as, say, tree clearing legislation or Fisheries Act, those sorts of non-criminal law legislative instruments, they themselves must have an element of intention called mens rea. Now, without an element of intention, the offence can't be proved. So the presumption is that every offence, even if it's something like tree clearing or fishing or whatever, every offence has to have an element of intention. So do remember that one. And finally, and you'll deal with this more in the next chapter, that Parliament intends to legislate in conformity with international law. So look, overall, just if I could finish with one overall comment, remember again that what we're talking about here are common law rules regarding statutory interpretation. And so in the same way as we talked about this in the previous week, the legislative framework takes precedence. So you're thinking about object and purpose, etc. But where it's possible, you can use these statutory presumptions to shore up your argument and strengthen your argument and take your case in a particular direction. But remember, if the clear word of the Act doesn't admit one of these statutory interpretations, then it's gone. Okay, well, enjoy your reading. We'll talk again next week.